jumping on here. So I'm going to hit the record button. As we always do, we record these and post them later, though I'm a big slacker right now because I haven't posted last month's yet. So probably should go do that.
Hey, Angela, it might just be on my end, but is Jess a little quiet to you? Maybe she wants to go into her settings if she can and turn up her mic volume a bit. That might just be on my end.
Yeah, that's a perennial problem with this system. What I have to do is get a little bit closer. Is that better?
It is.
Yeah.
Yeah.
Thank you, Cole. And feel free to nudge me if the sound gets low again. I don't like being this close in, but
Super extreme. Close up, right? Is that Wayne's World? I don't know. Am I dating myself?
Hey, I've seen it too. I love that movie.
Okay. Oh, so thanks to everybody that's hopping on here today. We will get started in just a few minutes. We kind of start a few minutes after the noon hour just to make sure that everyone can hop on. It's just the way the Eventbrite system sends out the access information. One of those weird little quirks that sort of we're stuck with. And today, we have Cole from Strongwell Property Management, and we have Jess Hyman from CVOEO. We're going to be talking about fair housing today. So bring your questions. We'll ask you to pop that into the Q&A when we get started, if you have any, and we'll get this off the ground in just a couple of minutes here. So, and we're going to miss Brian with his, his chit-chatty, his ability to fill airtime.
Yeah, well, and sometimes put his foot in his mouth. So maybe this is the best one for him to not be here for.
It's a learning experience. This is how you learn.
That's right.
Yeah, by coming to these seminars, like getting educated, asking questions, like that's how you become better at your business. And landlording is a business, property management is a business. And so, there's rules that you have to follow and things that you need to be aware of, just like for any other business. So.
Yeah, and we were saying it briefly before the recording started, but I feel like this is definitely one of those topics where people don't think about it at all until there's a problem.
Right.
So it's good to get as much of this knowledge as you can to avoid those issues. And really, it's about doing the right thing anyway. So.
Right. Well, and I think one of the challenging things about fair housing, and Jess, maybe you can weigh in a little bit, is I think many times people are trying to do the right thing and they are trying to be nice, and they don't realize that what they're doing actually is running afoul of fair housing, right? So it's one of these areas of the law where you almost have to take your human element out of it, because trying to be nice or be helpful can get you into hot water.
Exactly, and that's the thing, and that's why one of the most important things is to treat everyone the same. Unless, of course, they have requested a reasonable accommodation or modification because of a disability. But you're totally right. A lot of times people will make decisions or give particular opportunities or recommend certain things because they really think they're doing the right thing. Where, to follow the letter of state and federal fair housing law, that's just not okay. And that's why I love workshops like this, just to help share a bit more information and also encourage folks to reach out with questions. And our phone lines and email are always open. We love talking to landlords and other housing providers.
Nice. So I think probably we can go ahead and get started. If folks join late, they can always catch sort of the replay on the posting. So welcome, everybody. For those of you who don't know me, I'm Angela Zajkowski. I'm the director of the Vermont Landlords Association. And joining me today is Cole from Strongwell Property Management, who's also been co-hosting these seminars, monthly landlord management series that we're running. And we have special guest with us today, Jess Hyman from CVOEO. She's works on their fair housing project, among other things. And she's agreed to join us today for sort of a joint presentation on some fair housing issues. Because as we can see, April is Fair Housing Month. So there's a lot of seminars and opportunities happening. Jess, do you want to tell everybody about some of the upcoming events that are going on for landlords?
Sure, I'd be happy to. So, Fair Housing Month celebrates the passage of the Fair Housing Act in 1968. And so, to celebrate that throughout the month of April, we have a whole series of events and activities, and a lot of creative activities, informational activities, and resources. There are some specifically designed for landlords. So, in addition to the one today, there's one next Wednesday, April 20th in Burlington. That's an in-person event, which is very exciting, a roundtable and dinner discussion. And we have a whole slew of other events on our website. And I'll pop the event calendar into the chat, because there are many things that you all and your networks and families would, I'm sure, love to participate in. And I'll put that in the chat.
Excellent. So we have just a sort of brief presentation here with just some basics about fair housing. And so we'll get those running here for a little bit, and, feel free to post your questions in the chat. And Jess and I are going to be sort of co-presenting this piece with a little bit of back and forth. And this is just to give folks sort of that 30,000 mile view of what is fair housing, why was it created, what does it mean, why is it important, and just a few little nuts and bolts about it. So what is fair housing? And I mean, at its essence, it's creating sort of a system where it's someone's right. So the individual who's making the decision, it's their right to choose where they live. And not only their right to choose where they live, but to be able to do so without being discriminated against or harassed or pushed into a different direction. So really, one of the sort of basic tenements of fair housing is putting the burden or the choice on the person who's making the decision. And so really that's, I think a lot of times if we understand what some of these rules are or where we're coming from with the creation of rules, it can help you navigate them a little more easily. Okay, so that's sort of the basic, what is fair housing, but really what are we talking about in terms of being landlords? And some of that is learning and understanding what housing discrimination is. So the way the statute, and when I say statute, I am generally referring to both the state fair housing law and the federal fair housing law, which are very closely aligned. They pretty closely mimic each other. And so when I say statute, I'm usually referring to both of them collectively. Vermont has a few extra categories or protected classes, which we'll learn about in a little bit. But for the most part, the activities that are described or the case law or the various requirements are coming from both federal and state law. And so they really mimic each other. And so a lot of these, there's this long laundry list of things, and these all come from the statute. This particular set has been pulled from the Vermont statute. And so it means that you can't do these things because somebody belongs to one of the protected classes, which we'll get into in a couple more slides. So you can't not rent to somebody because they have kids, or you can't not rent to somebody because they are a particular color or because they have a disability. It also means that you can't create different requirements for them or have different lease terms. I think where we see fair housing gets super complicated super quickly is occasionally the answer is yes, right? So the typical one is like, you have a facility, it has a pool. You can have reasonable rules and restrictions, some of which may impact persons who are minors. So something like children under 14 must be accompanied by an adult, right? So on its face, you might say, well, that's a different term or condition for somebody who's a minor, but there's a very good safety reason or consideration for why some of those rules are in place. So and I forgot to bring in my book, I usually bring in my giant fair housing book and I hold it up and I'm like, this is why this area of the law seems so complicated. It's because it is, and it's very nuanced. And so, we're giving you sort of a global overview, but your particular situation may result in something different, or you may get a different answer, because one little sort of fact in a pattern can completely change a direction that you need to go.
And just to add to that too, so a good parallel example to the no one under 14 allowed in the pool area would be a rule that says children are not allowed to run in the hallways. So that would be a violation of the Fair Housing Act. You can have a rule that says no one is allowed to run in the hallways, but to have a targeted rule specifically towards children in that case would not be appropriate.
Right.
So it is complicated.
Right. And same thing with, you could have like reasonable quiet hours for a building, but they need to apply to everybody, and you can't just enforce them against somebody who maybe has a kid that's being loud. So it's, it's that sort of equal treatment. But there is some acknowledgement that in certain situations or in certain settings, there can be some restrictions. The pool is a good one. Fitness centers are another area where you can see those kinds of rules that apply specifically to age. But for the most part, they need to be, whatever rules are, need to be pretty neutral across the board.
Angela, would that be, could you expand a little bit on what the difference is between running in the hall or a pool or a gym? Is that because there is an expectation of danger in this one place for kids?
Well, or just, I think generally for people who may or may not be able to swim. And so water is, a known, or in a pool setting is a sort of a known drowning risk, where, running in the hallways, adults, if an adult was engaged in that and that was a rule, they should also be, reprimanded in the same way that a younger person. But that rule, no children running in the hallways, is directly treating kids differently for sort of the structure, with no sort of backstop for safety. So, if kids shouldn't be running in the hallways, then adults shouldn't be running in the hallways, right? Is sort of the analogy. If it's a trip hazard or a safety hazard. Whereas a pool, it's because of the age and the swimming and the drowning issue that we see those requirements sort of pass muster. I think it's the best way to say it. Jess, is that sort of match what?
Good assessment. Yeah.
Yeah. Yeah. And, with fair housing, you're going to hear me say a lot, well, it depends, because these situations and these scenarios are so fact specific, and so just based on sort of the individual situation and the unique facts for that situation. It is kind of hair pulling, because it's a little like, people want to know, just tell me what to do. And it's like, well, I can kind of, but not completely. So some other things to think about in terms of housing discrimination, it covers statements. So things that you would say or things that you would print or publish. So this goes sort of beyond perhaps your traditional advertisements. This could be Facebook postings. This could be, a marketplace. It could be a response to a comment somewhere. So just, again, be mindful of the words that you're using, because it could come back or could create a problem. You Also, if you're making sort of false representations about the availability of a unit, that's covered. So that's sort of the classic, well, I'm just going to tell them that it's not available, that I've already rented it, when you haven't, because that'll deal with this issue. But if that's actually not true, that can run you afoul of this housing discrimination statute. So if it's true and you have a lease with another resident and you have rented it, you can say that, but it has to be true. Denying access. So this this is part of the pool issue again, right? So you can't say no kids in the pool. Because you're denying access to that facility, but you can have those reasonable rules. No kids not supervised by an adult under the age of 14, right? So that's sort of this balance of the use of that facility, which is, why we see some of these gray areas and things that you're like, well, but that, why can you do it over here, but not over there? And then finally, the coercing, intimidating, and threatening folks if they're raising something with you related to discrimination, or sort of, pushing back on you a little bit. Jess may be able to speak more about what she's seeing from tenants in this. I will say, just on a federal level, there are some pretty egregious cases out there. Not necessarily here in Vermont, but there are some pretty horrifying situations that landlords and property managers, behavior they've engaged in, directed towards tenants or applicants when claims have been filed. But I don't know, Jess, what do you see here?
Yeah, and that we don't see as much of the egregious activity that happens in other states. However, the caveat is that so much of the discrimination and intimidation and retaliation that happens doesn't ever get reported. And a lot of that is fear of retaliation. And so especially, in such a tight housing market that we have now, where people are really afraid to lose their housing or to have it threatened in any way, that they often don't report. But we have heard of things such as, people, property owners threatening to evict tenants for making complaints about habitability, and other issues like that. When we go through, when we're done with the presentation, I'll give some more specific examples of things that come in through our Vermont Tenants Hotline and directly to the Fair Housing Project. And the other thing that I wanted to add to this list, the other thing that is also included under housing discrimination is failure to respond to or to provide a reasonable accommodation or reasonable modification for someone with a disability. And here in Vermont, discrimination based on disability is the most common thing that our enforcement partners at the Vermont Human Rights Commission and at Vermont Legal Aid see.
Would that be something like asking for a ramp or something like that?
Exactly. So, reasonable modification is a change to the physical structure of the dwelling. So, a ramp or a grab bar in the bathroom, or a blinking fire alarm instead of an auditory one, or a slow closing door. Those would all be reasonable modifications. And versus a reasonable accommodation, which is a change to a policy or practice that allows someone with a disability to live and use their home. So reasonable accommodations are more things like assistance animals, or a change in the way someone's allowed to deliver rent. And we'll talk a little bit more about that later too.
Exactly. So we keep talking about what these protected classes are, and I think many of these people are going to be familiar with. This group here is the federal list of protected classes, so it's the ones that I think we've been hearing about for a really long time: race, color, national origin, religion, sex, familial status, and disability. So those are the groups that the federal law applies to. And then this is, you know, one of the areas where Vermont has expanded a little more. And so they've created sort of some additional categories that Vermont said we're going to cover as well. So that's age, sort of marital status, sexual orientation, gender identity, receipt of public assistance, and then victims of domestic violence. So those are additional categories that are covered under the Vermont Fair Housing Statute.
And just to add a little bit more there too, at the federal level, HUD has now included sexual orientation and gender identity under sex. So that's a broader protection at the federal level, which is much needed. And then I also just wanted to expand on what receipt of public assistance means. So that is housing choice or Section 8 vouchers, 3 Squares Vermont, any type of public assistance. So anyone who's receiving any public assistance is protected in the same way as the other protected classes. And then the victims of domestic violence, so that covers sexual assault, stalking, and abuse. That's a not brand new protected class added in 2019. And it's also part of a whole host of other tenant protections that were rolled into Vermont landlord tenant law, which is a really important thing to note too, because it provides the ability for folks who are victims or survivors of domestic violence to get their locks changed or have additional security measures, or to break a lease in a case where they may be at risk. And so those changes are directly within landlord tenant law in Vermont.
And not to derail this too much, but that statute section related to additional protections for victims of domestic violence also provide some legal and liability coverage for landlords if they are taking action based on someone's falling within that category of being a victim. So there's protections for the lock changing and other things. So it's sort of a dual purpose statute. So it's not sort of one without the other.
Would an example of that be, that, there was fighting going on in the unit, and because of that, you don't want to renew the lease? That would be a breach of this fair housing?
I mean, it could be if one of the parties has sought status as a victim of domestic violence. If it's just a fight and nobody's reached out independently about that, and the landlord proceeds with not renewing the lease, that wouldn't run afoul of this. But if one of the parties reached out and said, I'm a victim, I need some help, I want this person excluded, there's a series of steps that the person seeking that status has to take. They're not super burdensome, but there are things they need to do and some documents they need to provide to the landlord. So, that could be a request, fight, landlord sends notice, victim comes, says, please, here's my status, please don't evict me, I'm asking for this accommodation because of that. And that would be something that you would need to review and consider and respond to as if it was any other reasonable accommodation request. And so you could run afoul if you were like, no, I'm not gonna even entertain this. So, yep, good question. All right, who is protected under fair housing? And that's anybody seeking housing. So fair housing, it applies to renters, it applies to home buyers, it applies to people looking for mortgages or looking for insurance. So it actually, it covers you as well in your own home and in your own home purchase. So it covers people occupying a dwelling. So this includes both the residents and anybody that's providing care to them. And where does it apply? So this particular section of the law applies to our residential dwellings. So it equally applies to, say, condos and condo associations, as it does to single family homes that are rented, as it does to apartment buildings. So basically any kind of rented sort of housing situation. And it also covers anyone connected to that housing. So, you know, as a housing provider, you're also to some extent responsible for, you know, how your maintenance staff is interacting with folks, what they're telling residents, what your cleaning staff, what contractors are, what sort of third-party vendors are saying to people. So, you know, there can be some sort of upstream liability if the personnel and vendors you've hired to come in are not following these rules and are or making statements or aren't interacting with the residents or tenants appropriately. And I mean, Jess, do you see this being sort of a big issue in Vermont? Are we running into this any with, you know, vendors or contractors or things?
It does happen, and I think what's most common is, say if a maintenance person is walking down the hall of an apartment building and a resident walks out and makes a request for a reasonable modification, you know, says something like, "Oh, I'm having some trouble, you know, because of my disability. I really need a grab bar in the shower. Could I please have one?" And the maintenance person may not immediately recognize that as a reasonable modification request, and there may or may not be a policy in place for that business to submit that request. And so if that isn't recognized as a request, it doesn't get made, then there isn't a response in a proper amount of time, and there could be a complaint filed. So things like that do happen pretty often. And I think there's also, we also see we hear a lot from condo boards, because it's a different type of a situation where you have, you know, neighbors in a position of power over other neighbors, and that's which creates its own power dynamic, which is, you know, similar to the landlord-tenant power dynamic and relationship, but often isn't recognized as such. And so often, you know, condo boards aren't as aware about fair housing law as they should be.
Right. Right. And some of that is just being aware, of you as a property owner being aware that you may need to have some training or have procedures in place for your maintenance staff, particularly if you have on-staff maintenance. If you have, you know, sort of third-party contractors, you know, if they're at the property, maybe just checking in with them, being like, did, you know, any tenants raise anything with you other than the work that you were there? Just, you know, doing that check-in to just find out if there's anything that you need to know about.
Yeah, that's exactly what I was going to ask about. Can a landlord protect themselves or insulate themselves a bit from this by having it in the lease where those kinds of requests would go, so that it's clear and agreed on that you would ask whoever the primary person is?
So landlord or property owners can have policies around that and can set up systems for requests, but can't require that all requests happen that way. So verbal requests are still valid under the law. So it's really a good idea to have a system set up and to make it really clear to tenants how to make these requests and have an internal process. That's fantastic. We wholeheartedly recommend that. And you also have to accept requests that come in any way.
Yeah, and I think that's one of the challenges when you're navigating this area of the law is it's going to be rare that a tenant is going to come to you in writing or even in person and say, hey, Cole, I need a reasonable accommodation request for this. It's going to come in a different type of request. They're not going to use those words. And so one of the challenges sometimes is trying to filter through, is this actually a reasonable accommodation request? And, you know, have that sort of thinking in the back of your head if tenants saying, oh, I need something like a grab bar, and to not automatically just be like, no. I mean, you may have to do some follow-up questions and say, okay, help me understand, where, I mean, but something like Radbour should be pretty straightforward to install sort of regardless. But so expect these to not come in with like the tenants using some sort of magic language. Yeah.
And we at CVOEO, we do our very best to help tenants understand the magic language, and all of our information and education around tenants' rights and responsibilities focuses on making sure that more people understand what their rights are under the law and how to request for these things in a way that is easier for the housing providers to recognize. Right. So that's where communication and relationship building is so important.
Exactly. And I think, the other piece here is, I've had landlords react sort of negatively. So they get the official request in the proper format, and then they're like, what is this? And why is and it's like, whoa, that's actually kind of what we want to see happen. So it's, also don't get your back up or be sort of really nervous if something comes in on a more official looking form. That's actually the tenant's trying to help you and help you understand what the request is at that point, not, try to get you in trouble or say, I have to give you this official form because you're not doing this thing. Like it is, again, it's that communication piece and communication issue. All right, and where else does fair housing apply? To all advertising and statements. This one was quite a bit less of an issue when people had to post ads in the newspaper, and then there was somebody at the newspaper that was also reviewing ads and would occasionally bounce them or not run them or send them back for revisions. With the number of places where people can just post on their own now, I think we're seeing more and more sort of ads with things that they shouldn't have in them. So just be aware, again, things that you say or things that you put out there could be violating fair housing. And the big one with the ads is describing the type of person you want to rent to as opposed to describing the property.
Do you, I know this comes up a lot in the real estate side and the real estate sales. What are some examples? I know I've come across ones that they say you shouldn't do, talking about a certain type of neighborhood or things like that, right?
Yeah, some of the things that come up that we see a lot are things like perfect for professional couple, or small, cozy apartment for single person, or we even see some that say not suitable for families, or no Section 8. So those are obviously much more blatant. But the key thing, just like Angela said, is to describe the dwelling, not who you think should live there.
Right.
And even putting additional things onto the dwelling, like saying like family, neighborhood, or something like that could be harmful, right?
Yeah, well, and that's where it gets a little bit blurrier, because if you're affirmatively furthering fair housing, and so if you're saying families welcome, that's okay. And another good practice is to, if you want to describe the neighborhood, so say if it's a house and you want to say is 3 blocks from a school, that's totally fine. Or you can list amenities and talk about what's in the neighborhood, but not who you think would benefit from living in that neighborhood.
Right. And I think, where it gets, again, really tricky, really quick is if you use something like quiet neighborhood, because that could give the impression to somebody with kids that maybe it's not a good fit because it's quiet. And I don't know about anybody else, but my 2 children are incredibly loud. So, but again, that's not, people with kids should be able to live there if that property is going to work well for them, even if it is a quiet neighborhood. So putting that kind of descriptor in could discourage them. So, that's a closer call and maybe a little more gray area, but again, it starts to wander over into describing who you want to live there versus what the property is and what the amenities are and what's included in the rental. So there are a few exemptions to fair housing, but again, keep in mind that the statements part of fair housing still applies to all of these rules, all of these exemptions. So that's sort of the you can think it, but you can't say it kind of approach here. So you can base your decision if you fall into one of these exemptions and make a decision based on a protected class. You can't actually say that's why you've done it. You can't advertise it that way. So the main one one of the ones I want to flag here, which comes up, is refusing to rent to somebody under the age of 18. And so the reason why this one is on the list is legally persons under the age of 18 cannot enter into contracts. And a lease is a contract between two parties. So they can't sign an enforceable lease. And so it's okay for you to say no if they're not old enough to sign a legally enforceable contract. Now with this one, I always get, well, what if they're an emancipated minor? Okay, that's different. And then there's a legal document that they can show you that says, I have the legal ability to do this. I have never seen one of those, never seen that come up. It's not to say that it doesn't exist out there, but I think the chances of you running into that maybe are a little slimmer. But these are all exemptions to that fair housing, and they all come sort of with their own requirements. Senior housing, if you're offering senior housing, there are a series of things that you have to comply with, rules and other regulations to get within that exemption. So it's not sort of as simple as I'm just going to designate this house senior housing and there we are. So it is more, there's more to it in some of these situations than just I say so.
The last one on the list, Angela, is that that you could not rent to a larger family if the unit just isn't big enough based on occupancy standards. Is that what that's saying?
Well, or that you wouldn't rent to X number of people if they exceed the occupancy standards. So it's sort of more than just sort of a family. I have done calculations in math for a lot of the occupancy standards, and you can have a shocking number of people occupying a unit based on most occupancy standards. So, I mean, we include it because it does exist, but just, be careful and make sure you're doing your calculations right. It's not 2 people per bedroom. That's not the standard. But some municipalities have occupancies based on square footage of bedrooms or square footage of living space. But I think, for the most part, if you did the math, a lot of people would be able to live in that unit. And so why is fair housing important? Why are we spending all of this time talking about fair housing? Why were these laws put into place? I mean, fundamentally, it's about creating fairness and equal opportunity for people. So, there was a long history of certain groups of people being excluded or not being able to apply for certain types of housing, being turned down because of that. And so we have these rules that have been created to make it more fair or try to make it equally fair for everybody. So it's, in its essence, it's about equality and trying to make things equal for everybody.
Yeah, and if I could add to that too, I think that a lot of the housing situations that exist all over the country, including in Vermont, were designed based on systems that were unfair and that have been sort of perpetrated over the years and through generations. And so, people of color and other folks in protected classes have been excluded from housing opportunity. And, we all know how important our homes are. Where we live determines where our kids go to school, how we can get to work, access to recreation. And so when entire groups of people have been excluded from all the things that allow for, vibrant, healthy families and vibrant communities. It changes the playing field, makes it an unfair playing field. And so, the fair housing laws, aren't just about protecting from discrimination, but they're about changing some of these systemic patterns that are ingrained into how our communities are planned, how and where housing is built. And so it's a big job, and it's really important. And I think it's especially, when we think about the last couple of years of the pandemic and how closely connected our homes are to our health and to opportunity, it's more important now than ever. And that's another reason too, that as housing providers, you all play such an important role in our communities and are providing what everyone needs, a safe and stable home. And so it's I could go on and on about this, but we're going to go through the presentation and then talk more about it in the Q&A in the Q&A section.
So I flagged a few, like 3 sort of big areas that I know I get a lot of questions about, and I think we see a lot of issues, a lot of complaints with the Human Rights Commission, sort of surrounding these sort of 3 areas. So emotional support animals is definitely a large one. That actually follows as sort of a subset of a reasonable accommodation request. But we have reasonable accommodations and reasonable modifications. And then sort of at the application stage, so where people are applying to rent. Those are sort of the big sort of like zones or places for folks to just be aware of. And then the last one is statements. So again, that's that advertising piece. That's that what you tell somebody during the application phase. That's what you maybe write to them in an email. It's all of those things. So again, to just be mindful of how you're communicating with people. So emotional support animals. This is an area where someone can ask for a change to a no pets policy. So they can have an assistance animal which helps them with some symptom of their disability. It can be any animal. So this is not one where the type of animal is restricted. And there's no sort of special training required for this type of request. And so we tend to refer to these as emotional support animals or support animals. Many times they are tied to some sort of mental health issue or sort of mental health disability, which is why we refer to them a lot as emotional support animals. But it could also be something like the traditional sort of seeing eye dog, or a dog that can sense if somebody's going to have a seizure. There's a lot of different types of needs or animals or reasons why these requests are made. And I know one of the more challenging aspects to this for landlords is that this is a request that can be made at any time. So there's no requirement that the tenant make it when they're applying. It's something that can come up after they move in. It's not like there's a narrow window for the tenant to make this request. And if they miss that window, it's like, sorry, too bad, you're already here. And I know that's incredibly frustrating for landlords. It's just the way the law's written, and that's just the way it is. So, your tenant can make this at any time. It can even be made after you've sent them that termination notice for having an unauthorized pet. And then they come back and say, oh, wait, it's not, here's my reasonable accommodation request, which you then have to process and could remove your eviction notice for having an unauthorized pet if they meet all the requirements and the animal is approved. So I know it can be incredibly frustrating to deal with something like that, but that's just the way the rules are written. And the way they have developed through case law in a lot of other places that then we have to follow as well.
And an important addition to that too is the request has to be made. So
Right.
we often hear from folks saying, that, oh, my landlord is telling me that I can't have this animal, but it's an emotional support animal. And so we'll ask them, well, did you make a request? And they'd say, oh no, well, just the fact that it's an emotional support animal should be enough. And so, that request does have to be made, and there has to be a relationship between the person's disability and that request. So as property owners, you're not allowed to ask what that disability is, but you can ask for documentation that there is a nexus between the disability and the animal. So, a health professional's note saying that simply says, because of a disability, this person requires an emotional assistance animal. So, there are steps that do need to be followed under fair housing law for this really important resource to people with disabilities to be used.
Right. And I think the other thing to point out here is granting the request and having an animal on your property that has been classified as an emotional support animal does not mean that it's a free-for-all on sort of behavior and other issues. So you can have an assistance animal addendum, and I will say the one that I use and recommend looks exactly like my pet addendum, except we've removed the requirement for a deposit to be paid. But in terms of like the type of behavior, I mean, you can require that it not disturb other neighbors, that if it's a dog, it's licensed, that it's up to date on its vaccinations, that the person picks up after the animal, that it doesn't cause any damage. So, I mean, you can have sort of those reasonable rules and requirements related to the behavior of that animal. And if the tenant is not following those rules or the animal is not following those rules, that can be a basis to ask somebody to leave, to either remove the animal or to leave the property. So it's not just this like, well, it comes in and then there's nothing I can do because it's an emotional support animal. That's not actually true. You can have those sort of reasonable rules and requirements in place.
But you're not allowed to have an additional deposit?
No.
Is that what you're saying?
Right.
Yeah, there can't be any additional costs associated with having an assistance animal.
Right, which would include an extra deposit, even if you charge deposits for pets. Now, if you are in a pet building where you allow pets, you may get requests for reasonable accommodations for emotional support animals anyway, right? Because it's not a pet, it's somebody's support animal. And then you cannot charge that, whatever that pet deposit would normally be. So you may still get these requests even if you have a pets allowed building, because it has a different legal status, this animal, than a regular pet. So again, these kinds of requests, don't ignore them. When it comes in, if there's more information that you need, or again, maybe that tenant really hasn't quite made that connection for you for the nexus, it's okay to do that follow-up. But I think the two areas where landlords can run into trouble is just immediately saying no, or just ignoring it, because ignoring it's the same as immediately saying no. So you have to have sort of this back and forth with a tenant, make sure you have all of the information, and then ultimately make a decision. Most of the time, the tenant is going to provide you with the required documentation to support their request for an emotional support animal, meaning that more likely than not, the animal is going to come in under a request.
I think I remember at one point in a previous session, you talking about that you just ask for that documentation. You're not going to be probing and asking about their health or anything like that, correct?
Correct. Right. You don't have the right to ask what their disability is. You don't have to, you do not have the right to ask for diagnoses or sort of the details, medical history or medical records. But you do have the right, unless the disability is very obvious, to ask if they have a disability. So to get confirmation that they do have a disability, that the animal is going to alleviate some symptom of that disability and sort of is necessary to support them in their living environment. So, and most medical providers are aware of these requirements, and that's why you get those letters that say, so-and-so is a patient of mine, they have a disability, they're requesting an emotional support animal. Sometimes they know specifically what the animal is, which will help alleviate some symptom of their disability. Like that, I've seen a lot of those kinds of letters, and that's why they're written the way they are. I will say what does not qualify, which we have seen, is the tenant who goes out to the internet and pays the $75 to have their animal certified as a service animal. That does not meet the legal standard and is not qualify that animal under this system. So just be aware those are out there, and you may see them occasionally, and that does not cut it here. Okay, applications to rent. So this is some of this basic thing where you want to treat everybody the same, and really by treating everybody the same, give everybody an application. So give everybody an opportunity to apply for a unit, make a decision about whether that unit's going to work for them as an individual or as a group. And please do not do these sort of pre-screening calls where you're asking sort of a series of questions and then refusing to show the unit based or give an application based on sort of those pre-screen questions. So, just remember, it's the tenant's job to make a decision about whether a particular unit's going to work for them or not.
And just to add to that too, that applies to every part of the application process. So if you request, if you do a credit check for one tenant, you have to do a credit check for all the tenants. And that's where folks can get into trouble a lot, because they'll make determinations about who might be a riskier tenant than another person. And so it's really important to be consistent. A call that we just got today was from a tenant who was renting with a group of people, and the landlord requested a higher security deposit from one of the tenants because this person came from another country. And so that's a blatant violation right there.
And I mean, I could see the landlords thinking, well, they don't have credit history. They don't I don't have a method of collection. I don't, sort of the normal, and not thinking of sort of this other issue that they've now just sort of stepped in by doing that. Yeah. So, and then statements, we have talked about this quite a bit off and on throughout this presentation, but what you say or write can be discriminatory. It's not a situation where intent, so it doesn't matter if you don't intend to be discriminatory when you make the statement. Is the statement discriminatory? So, this is one area to be, very mindful of the words that you're using, what you're saying, what you're writing, to just, take a moment and think sometimes before responding, or before sort of taking action. And so
we do have our first question in on the animals. They're asking, Jenny is asking, how does a landlord pursue compensation for damage inflicted by emotional assistance animals without asking for that additional deposit? And you can give the answer, but I'm guessing you have to just attempt to get it after, right?
Right. Yep. It could come out of the regular deposit that was paid for the unit. It can be pursued in small claims court. Sort of the general way is that any sort of damages in excess of a security deposit would be pursued from a tenant. But I think that is one of the tensions here with this area of the law is, as housing providers that when an animal situation goes awry, the level of damage that can be inflicted on a unit is enormous and can have a very large cost associated with it. And this is one of those areas where when the laws were put into place, that's just a decision that was made is, look, we're not going to place additional financial burden on folks who are requesting accommodations under these laws. Landlords and housing providers, you will have the sort of normal collection routes of the regular deposit and small claims court, but we're not going to have that financial piece be an additional impediment to this person and their use of the unit.
So what kind of penalties are we talking about here when landlords aren't following these guidelines?
Many times it's financial, and if it's the result of a complaint that's investigated by the Human Rights Commission, or sometimes it's a lawsuit brought by Vermont Legal Aid, or the tenant themselves or the applicant themselves. We're talking financial penalties, and it really depends on what the violation is. Sometimes it's enough for the person to hear an apology, know that the landlord's going to go have some fair housing training, is going to have to put some things in their lease about how they follow fair housing. And sometimes it's a significant monetary payment. It just really depends on what the issue was.
And this I don't think, correct me if I'm wrong, Angela, but we haven't seen something like this in Vermont. But in other states, there have been cases of injunctive relief where, a housing provider is barred from ever owning rental property again. And so for some of the larger, really egregious cases of ongoing sexual harassment or abuse in housing, which has happened in some big cities, that's what can happen there. And I think it's really important to note too that when a complaint goes to the Human Rights Commission, their first step is to try and solve the problem and to have a mediated conversation and to do something to see if there can be an agreement between the parties. That's always the first step before things go to court. And I think that's where the education, the communication comes in as well, which is really important. Because here in Vermont, the most common types of discrimination that get reported are based on disability, and then followed by family status, so mostly having kids, and then after that, the third most common area is skin color or national origin. And I can share a couple examples of things that
Sure.
come into our hotline if that would be helpful for folks.
Absolutely.
Yeah, so some examples are a landlord refusing to show an apartment to someone because when the person called, they said they had a housing choice voucher. That's something we hear quite a lot. One call that I got just a few months ago was someone who was looking for an apartment with her partner and her kids, and she's a woman of color. And when she went to see the apartment, the landlord asked her if her partner was the father of her children. So first off, that's terrible. And then required more references than he was requiring from other applicants. So treating applicants in different ways. One thing that comes up a lot is steering, and a lot of times steering can happen out of the goodness of someone's heart of thinking that they're helping someone make a decision. So for an example, a Nepali family who was guided to an apartment in a building that had other Nepali families, and when the Nepali family asked to look at one of the owner's other apartments, other buildings, the owner said, "Oh no, I think you'd be more comfortable here," and maybe that would have been true, but it's not up to the landlord to decide. Another example that came up recently was a condo association refusing to provide a designated parking space for someone who has a disability. So they have an open parking at their units. And so we get a lot of calls on our Vermont Tenants Hotline and through the Fair Housing Project. Most of the calls are more related to landlord-tenant law, concerns about habitability and lease questions. And then there are always some fair housing issues. If I could put in a resource for folks, there's a fantastic document developed by CVOEO and the Vermont Landlords Association called The Definitive Guide to Renting in Vermont, and I'll put a link in the chat. We just updated it just last year. Incredible resource, and it just lists all the rights and responsibilities on both the tenants and the landlord side.
And we tried to write it not filled with legalese. So we tried to write it in a way that everybody can understand. There's pictures, there's graphics, like we tried to make it as straightforward as possible for everybody.
Great resource. So I'll pop that in the chat along with some other resources. Another thing I wanted to mention, I hope we have time, is that CVOEO offers tenant skills, finding housing, and rent right workshops for renters. And a lot of housing providers actually recommend these to their tenants so that tenants can understand their rights as well, their rights and their responsibilities. And some housing providers actually require that tenants take some of our nonprofit housing partners like Champlain Housing Trust. If someone's application is denied, if they take one of these classes, then they're back on the list. So that's something you may want to consider as well.
I know that we're almost out of time here, or we are out of time. Can I ask you one quick question that has been coming up a lot in my world in sales, with the market being so intense on home sales? The issue of dear seller letters has been coming up a lot. It's been coming up at the national level. Do you want to take a quick minute and give your perspective on that? We do have realtors that listen to these also.
Yes, yeah, I'm so glad you brought that up, because on the surface, a dear seller letter is wonderful. It allows a potential buyer to tell their story, to maybe be the one that's chosen. But what it really means is it provides an opportunity for discrimination, because everyone's decisions are based on both explicit and implicit bias. And when you're looking at a group, you have 10 dear seller letters, you're going to learn things about that person. Maybe there's a photo. You might see what their family composition is. You may see what their skin color is, whether they have a disability or not. And decisions made on those letters can be discriminatory, and so we do not endorse them, and which is a tough thing, because in this market where there just simply are not enough homes for everyone rather, buyers do want to get a leg up, but what happens is it creates an environment where discrimination can happen, and as real estate professionals, that can get you in a lot of trouble.
Yeah. And it's the seller who's really exposing themselves, right? Yeah.
Yes, and so it wouldn't just be the seller, but anyone involved in that transaction as well could potentially be liable. Yeah.
Yep. I mean, this is one of the few areas of the law where there can be some personal liability for folks. So, you put your properties in sort of an LLC to protect, or you have, business that you run, but the person who, makes the statements or is engaged in the act can also have some direct personal liability, individual liability that can run with some of these claims as well. So I think, we're at time. So Jess, thank you so much for joining us today. And and Cole, thank you for, hopping on and joining the conversation. And for everybody who sat through this, we hope you have learned a few things. And if you know anybody who could benefit from listening to this presentation, we will be posting it up on the Vermont Landlords Association YouTube channel. I will be better about getting them posted in a timely fashion. In fact, I should go do this as soon as it downloads, so it's done. But thank you, everybody. We will see you back again next month. So we always run these on the second, third Thursday of the month. And I don't know if we have a topic picked for next time, Cole.
I don't believe that we do, so we'll send out a email with that. And,
TBD.
yeah, and anybody listening or anybody seeing this, send in what you'd like to hear, because we have a great resource with Angela and you know, obviously the great partners that you bring in too. So.
All right, excellent. So thank you, everybody, and we'll see everyone next month.
Thank you.
Thank you.